My name is Lisa Sifry, and I'm the Director of Plan Giving at the New York Botanical Garden. Thank you for taking the time to view the recording of our webinar, Planning Your Estate from the Ground Up, which was live on March 4th, 2021. As you view this webinar, there are two things I'd like you to keep in mind. The first is that tax laws change every single day. Some of the information may be dated as you are watching it. The second is that not all estate planning is one size fits all. Some of the information might not apply to you. We simply want to provide you with a foundation of information that you can then bring to your attorney or financial planner. Thank you again, and I hope you enjoy. At this time, I'd like to introduce our special guest, Julie Sakalariadis, who is Vice Chairman of the NYBG Board of Trustees.
Good morning, and on behalf of the New York Botanical Gardens Board of Trustees, I'd like to thank you so much for supporting the garden through your dedication as members, patrons, and members of the Perennial Society. For those of you who don't know, by definition, a Perennial Society member is someone who has included a gift to the garden in his or her estate plans. When you make a gift to the garden through your will, trust, or beneficiary designation, you're investing in the future of this unique institution and supporting our mission to save the plants of the world. You also benefit humanity because plants make the conditions of life on Earth possible. They make the air we breathe, the food we eat, the clothes we wear, and the homes we live in. The scaffold for all living creatures, they also gift us with the beauty and joy that make life meaningful. And now I'm delighted to introduce our guest speaker, Barbara Kane, Esquire. Barbara is a graduate of Harvard-Radcliffe College, magna cum laude, and a cum laude graduate of Suffolk University Law School. She speaks frequently on estate planning and charitable giving, including on public radio, and writes widely about this subject for publications such as Financial Planning Magazine. She founded her own law practice, Kane & Boniface, in 1991. Thank you so much for joining us today, and please enjoy the webinar and time with Barbara.
Thank you. I'm delighted to be here in every sense of the word. I would, in days of yore, I used to begin my presentations by quoting my father-in-law to the effect that immortality does not run in our family. We don't need that reminder today. This has been an extraordinary year. This is approximately the anniversary of the pandemic beginning. And to date, as of yesterday, 518,000 fellow Americans had died of COVID, and another 2,369 died yesterday. Most of us have spent the last year feeling very nervous about things, anxious, and most of us knew at least one person who was among those who died. So mortality is on our minds, very much so. We want to understand what happens when we die. We want to understand the steps we can take to help it play out in the way we would have wanted it to play out. At the same time, it's an anxious time because it's hard to reach our lawyers. And we may be nervous about getting on a train or in a car or whatever. It's a time of isolation, obviously. I do want to say that our firm, Kane & Boniface, and I see on the captions it's coming up as K-A-N-E, it's C-A-N-E as in sugar and candy. We are able to do initial consultations by Zoom or by telephone conference, to exchange drafts by email or regular snail mail, and then arrange signings at the NIAC office if that's an option. And as long as the governor still allows it, we can do virtual signings, which means that it's done over Zoom. It's a little technically difficult, but we can do it. as long as that's allowed under New York law. So today I want to help you understand from a legal and practical perspective what happens when you die, and to focus particularly on the things that you can do right now, today, to help make your own plan. It's always helpful when times are uncertain to be able to take something into your own hands and deal with it. So that's what I want to focus on. I will touch upon techniques for charitable giving because the garden is dear to our hearts. I want to highlight a few recent tax law changes and discuss the role of trust because many of you have asked Lisa questions about that. Shakespeare said that death, a necessary evil, will come when it will come. And even if you were expecting death and it's imminent, when it happens, like giving birth, it's always a surprise. And in that time of sadness and shock, people have to make decisions quickly. The first decision is what happens to your body. Is there going to be a cremation, burial, a service somewhere, some rituals observed? All of those are decisions that must be made, as well as, are you giving donations of your eyes and organs to be used by someone else? Do you want donations in your memory to be made to a charity like the garden? We advocate making those choices as far in advance as possible and writing it down. On our website, there's a little piece of information called memorial requests for you to say who's going to make these decisions when you're not around, and also who should get donations in your memory. It's always good to leave those instructions, but it's very, very useful to go a step further and actually pre-plan what is going to happen when you die. This you can do right now, today. You can call up a funeral parlor and listen to the menu of choices. You may know already what it is that you want, but make those arrangements, make your choices, give all of the information that would be needed for an accurate death certificate to be produced. You can go ahead and pay for those services right now. You can do it by check. And most of the funeral parlors are very helpful. If death is imminent, they'll take a credit card over the telephone. It's worthwhile to do this. I remember years ago, I had done a whole lot of planning for someone and it was relatively complex. And the family said to me, the most useful thing that you did was tell us to pre-plan. So only one phone call had to be made when the time came. The next challenge is getting your property to the people and institutions that you want to have it, and in the way that you want to have it. As an estate planner, I'm really concerned about having that process be as smooth as possible and saving taxes, fees, and heartache in the process. So suppose you had died last week. Here's my little coffin. And imagine that this box contains everything that you own or control anywhere in the world. This is real estate, it's investments, it's everything that you own or control. This is the beginning, the starting point for figuring out the gross estate in terms of value. And it's also the starting point for figuring out what items there are that need to be distributed. In the old days, it used to be fairly easy because somebody dies, you watch the mailbox for a few weeks. and statements come in and correspondence and so forth that tells the survivors what the person had. That's not true anymore because so many things are online. It makes it more of a challenge to figure out what's in that box. As a first step, and we routinely do this when we're helping people settle an estate, you can go online to unclaimed funds. You can just Google that from your computer, Unclaimed Funds New York, and it will take you to a site and lead you through a process to find out if there are any unclaimed funds in your name or in the name of a family member. Usually these are small, you know, the receipt from the initial deposit you made for your contract with the gas company, Con Ed or something like that. But once in a while, it can be a fair amount of money. We had one client, we did this, and there was $140,000 of stock certificates that had been lost. So do that today. You'll get at least that piece notified, you know, identified for the box. And if there's an unexpected surprise, you could consider giving that to the garden right away because you didn't even know you had it. Of course, if you don't take any steps to identify things, it becomes a kind of treasure hunt for the people who are left and have to deal with this. So it's a great idea to make lists of everything. I like to think of it in terms of two kinds of lists. One list is about keeping the lights on. If you're gone, how does the rent get paid? What's the Con Ed account? Is it paid automatically online or is a check written every month? All of these things would be on the keeping the lights on list. The other list would be of your assets, your investment accounts, your bank accounts, your life insurance, your IRA, your TDAs, all of those things. And the more information you can give, the better. You would like to have it identify the asset, have an estimate of what it's worth. And this is fair market value today, or in fact, it will be figured at the date of your death, like a snapshot taken at that time. But you could do your best to estimate it. You know, if you know, your house is worth roughly 300,000 or 3 million, you know that. So write that down. And give as much contact information and detail as you can. If you pay online, write down not just the account number, but what's your username and your password to get into that account. These things might sound unimportant, but they're in fact hugely important because the time and effort of gathering this information after somebody dies really translates into expense. About a dozen years ago, I was involved in settling an estate of a woman who died shockingly by herself in her apartment, and she was found there several days later. She was also a hoarder, and to figure out what there was, we had to go through every single drawer. And she liked to keep accounts at every single bank that was giving away a free toaster. So it was a huge job. It wasn't a large estate, but it was a very huge job in terms of time and expense to figure out what that stuff is. So you can do that yourself. When you have that list, you can look at it and get an idea of what your gross estate is. That's what the value of everything you own or control. That will be the basis of figuring out whether or not estate tax will be due on your estate. And if it is due, it must be, the return must be filed and the taxes paid within 9 months of your death. So it's important to be able to put this together in a timely fashion. Most people will not have to pay estate tax today because the exemption amounts are very generous. For New York State, for people who die this year, it's $5,930,000. And under the federal system, it's $11.7 million. And so those are pretty high numbers, but those numbers can go down at any time. There was talk in the paper this weekend of some people advocating reducing the New York State amount from that nearly 6 million number down to 250,000. So you need to keep track of this and plan for it. Our firm handles New York State, Connecticut, New Jersey, and Florida. Those that the attorneys in our office are able to cover that. And the rules are slightly different for each of them, but the general idea is the same. And you want to know what the gross amount of your estate is. If it changes, it's more likely today to go down in terms of the exemption amounts than going up, because obviously there are huge debts that the government has, people are hurting, money has to be raised. And as my son used to say when he was in high school and I just started doing this, he said, "Ma, if you can't tax dead rich people, who can you tax?" And that is very much the feeling of the future for the government. So these lists will tell you what there is in your box. And oh, somebody is just asking there. Yes, in New Jersey, there is an inheritance tax as well as an estate tax. And my partner, Courtney Boniface, is admitted in New Jersey and can fill you in on all of that. Okay, so once we have the gross estate and we have an idea of what comprises your estate, the next thing to do is to look at how those assets pass, how they get to the next person. And there are 5 basic ways that those happen. One is by beneficiary designation. Another is by operation of law. Another is by trusts. If you have done absolutely nothing and an asset is in your own name, it will go by intestate succession. That means according to the laws of the state. And it can also go according to your will. Of those 5 ways, the last 2 are disfavored by me anyway. Intestate succession means that state law dictates who gets what. This might be fine, but it also might be very, very disadvantageous to your situation. And you can count on the fact that it will never, ever include a friend. It will never, ever include charity. And it will mean going to court. That is a given. And the court will also have the power to decide who is going to be in charge of this process. A will is a step in the right direction. It gives you more control over what is going to happen. However, a will definitely need a trip to court in order to settle your estate. And sometimes people are very shocked and in fact mad at me when they come for help with these matters. And they say, "This is terrible. I have a will. My mother had a will. Why do we have to go to court?" Well, The very nature of a will is that you have to go to court. That's the probate process. And in that, the executor goes to court and shows the court the will. And their job is to prove, that's what probate comes from, probo, probare in Latin, to prove. And you say, here's mom's will. Oh yeah, prove it. And you show the right list of witnesses that have been there and so forth, and that everything was filed properly. And then you get to go to the next step of actually giving things out. Now, especially in the times of COVID, it's really not great to be relying on a will because the courts are at a very limited capacity. And so everything takes even longer than it would otherwise. The other feature of going to court and working through a will is that even though you have your will and you have said who you want to get things, the court will send, as I call it, an engraved invitation to everyone who would have taken if you had not had a will. This means that relatives that perhaps you didn't want to involve in this process at all, and you don't want to give anything to, get a notice from the court that says, guess what? Barbara's dead, and we have her will in front of us, and you have an engraved invitation to come in and say why you think it is wrong, and by implication, why you think that you should be getting something. I don't like this process. It's cumbersome and it leads to various troubles. Also, if you live in one state and have property in another state, you may be in the situation of having to do a probate in, say, New York and also one in Florida. This is not a good way to go about it. So what's a better way to do it? The better way is through a trust. And the kind of trust I'm talking about to begin with is a grantor trust, a revocable living trust. Every trust has a grantor, the person who sets it up, the trustee, the person who is in charge of carrying out instructions, and a beneficiary who the trust is set to benefit. In a revocable living trust, and here I'll use my lovely salsa container from Trader Joe's to show you a trust. You are the trustee, the grantor, you set it up. You are also the trustee while you're alive and competent. And you're also the beneficiary while you're alive. And into this trust, you can put all sorts of assets. You can put in your house. You can put in the stuff in your house, your household effects, your frying pans and bookshelves and what have you. You can put in commercial real estate. You can put in your cooperative apartment. You can put in LLC interests. And if you put in shares of an LLC, what also goes into it automatically is the cash or other assets of the LLC. You can put in your jewelry. You can put in your art. You can put in that vacation home in Florida or Hawaii. You can put in all of your bank accounts. You can put in all of your investment accounts. So this is a very, very useful thing because it can hold all of that stuff. Now, it has other advantages. When I die, the trust does not die. It's still a live legal entity. What happens is that my successor trustee, who I have selected in the document, steps in and takes control of it, and then goes through and says, oh, okay, this investment account has to go here, there, or wherever. And does not need the intervention of a court in order to make this transition from me being both the grantor and beneficiary and trustee to I've gone and the successor trustee comes on. Now, this is an arrangement also that is very, very flexible. I can say at the end of the day, I want all this stuff to go to my dear daughter. But if she's not around, the contingent beneficiary is whoever, could be charity. A useful example of this is, let's say it's my case. I have a husband and I have 2 children. I have 5 grandchildren. And they're the main ones I want to benefit. But suppose we celebrate my birthday and I invite them all and we're going out for a very big event. It's going to be, in fact, a trip. And we all meet at the dock and we get onto the Titanic. We need something and someplace that all of this stuff is going to go in that event. And you can do that here. So it's an enormously flexible and useful tool inside the trust. And I don't, oh, and you can change it anytime you want. And that means you can do amendments whenever you want, and it's relatively simple. So that's why it's called a revocable trust. Now, it's possible that I have some other asset that I forgot to put in here. I'm going to have a pour over will that will pick that up and stick it in here in case that happens. But I'm going to be relying on this to do the work. Now, I don't have one with me, but in my office I have one of those Russian nesting dolls, you know, a Mereshka, and you take off the top and there's a little doll inside and another doll inside that. This revocable trust is sort of like that, because inside it, you can have additional trusts. For example, suppose money is going to my grandchild. Brilliant and wonderful as they are, they're not going to be able to manage it if it goes to them now. So I would want to have a trust for minor children. I also would want to have a trust for a grandchild who has disabilities. I would want a supplemental needs trust, an SNT, that can live inside here. I might want to have tax planning for the benefit of my spouse and my children. Those would be marital trusts, bypass credit shelter trusts, maybe a generation skipping trust. All of those can live in here. I could also set up a charitable trust in here. This is enormously flexible and useful. So I prefer that to a will. Let's go back a bit to the other things that are possible ways of transferring property. A very important one is the IRA. This passes according to whatever you wrote on a beneficiary designation, maybe very long time ago. One thing you can do today is call up the place that your IRA lives and find out who the heck you wrote as your beneficiary. We always suggest this, and usually clients say, oh, that's ridiculous. I know it's so-and-so. And we say, humor me, just check. And we had one woman do the just check, and it turned out to be her former boyfriend. This was not a good choice as beneficiary. People can also forget after divorce to take their spouses off that. They can name their parents when they're a young working person and then get married and forget to name their new spouse. And we had that case in our office. I don't have to make these things up because they come into the office. And in that case, the parents did not care for the wife. So it was a fight to get that straightened out. The beneficiary designation is extremely important, and it can be individuals. It also can be charity. And I invite you to think very carefully about your IRA. Whenever money comes out of that IRA, it will be subject to income tax, because income tax has never been paid on it until the day it comes out. This means, for example, that if I name my nephew as beneficiary of my IRA, he gets, let's call it $20,000 minus the income tax on that. If instead I make it payable to the garden gets the entire amount, the entire $20,000. So that's a very smart way to do it, to give the IRA funds to charity and give other assets that would pass without an income tax consequence to individuals.
Hi, Barbara.
Yeah.
Well, so one of the questions, and actually you just addressed it, and one of the things that I wanted to mention also was when you're dealing with an IRA or any type of retirement asset, that's regardless of whether or not your estate is large enough to incur any estate or inheritance taxes. It still is a taxable asset regardless of how big your estate is.
Absolutely, because now we're talking about income tax, not estate tax, income tax. Because we all loved IRAs when the money was going in there, because we got to take an income tax deduction when we were doing it. And the money inside it got to grow income tax free. That was great. But once you die, the money comes out and you pay income tax on it. Income tax is paid. Now, the other thing that happens is now I'm turning, I plan, tomorrow I'm turning 76. So I have to take out money from my IRA every year, called my RMD, my required minimum distribution. Every time I take those required minimum distributions out, I have to pay income tax on them. And I must take them out whether I need the money or not. There's a unique opportunity called a qualified charitable distribution, a QCD, where I can say to the people who hold my IRA, I can say, oh, by the way, I don't want this year, please pay it to the garden. I can do that for up to $100,000 a year. And it's a great thing to do. You're not getting a tax deduction for doing it, but you're getting something under the structure of today's taxes that is even potentially better. Namely, it's going to a charity and it is not going to you. So let's say I did that for $100,000. That means my taxable income for this year is $100,000 less than it would have been otherwise. And I save taxes. The other thing is that, and this is changes in tax law. There's a huge change that happened in 2020 under the Secure Act. And that is the following. It used to be that my IRA, I could say upon my death, this goes to my husband, and then it goes to my dear children. And under the old rules, there was something called a stretch IRA, which meant that those beneficiaries could take the money out over their lifetimes. So my husband's about the same age as I am, a little older, so his minimum distributions would be about the same as mine. My children are 25, 28 years younger than I am, with a long life expectancy. So they would have been able to take the money out over their lifetime and stretch out the income tax consequence of that money. Well, under the Secure Act, game over. No more stretch IRA. And what that means is that except for a surviving spouse, a minor child, not your grandchild, your child, a person with a disability, a beneficiary less than 10 years younger than you are, though anybody other than those limited class of people will have to take out the IRA money over 10 years and pay income tax on it. Now, let's say you have $50,000 in your IRA and it goes to your daughter. Okay, she's got to take out $5,000 a year and pay tax on it. Not a huge deal. Let's suppose it's a $500,000 IRA. Now she's got to take out $50,000 a year. That's a lot of money to add to income. Maybe it pushes her into a higher bracket. But let's suppose you have a really big IRA. Let's suppose you have $5 million in an IRA. Let's say you're the surviving spouse and your spouse's IRA has been mixed with yours, and now you have a $5 million IRA. That goes to your daughter. Your daughter is going to have to take out $500,000 a year on average over this 10-year period. You can take it out in different ways, but for the sake of simplicity, call it $500,000 a year. That is a huge income tax impact. What can you do about it? Well, one thing you could do, and this you do need a lawyer, you do need help from Lisa or other professionals in planned giving and your accountant to look at it. But you could say that your IRA upon your death goes into what's called a charitable remainder trust. And that charitable remainder trust, in my example, I would be the donor. The trustee would be someone else. Maybe it's my lawyer, maybe it's the charity. That gets chosen during the course of planning this. When I die, the IRA for $5 million goes into this charitable remainder trust. And I can direct that the trustee pays out income at a certain rate to my daughter over a 20-year period instead of a 10-year period. There are different details of how to work this out, but the point is that instead of squeezing the income into a 10-year period, I've now extended it to a 20-year period, blunting the effect of income on my daughter. And at the end of the 20 years, a magnificent gift goes to charity. So that's not for everybody, but it's something to think about. And it could even be of use, well, that's from the IRA.
Now, Barbara?
Yeah.
I have one question, and it's actually regarding Roth IRAs and if there are different tax implications if you were to leave it to an individual or a charity.
Well, the Roth IRA has no income tax when it comes out. So it's different, and that's a technique that people can use if they have Roth IRAs. The income comes out to their beneficiaries without the income tax. Great.
Is there a time limit that they have to take it out as with a regular IRA?
Yeah, I think I would have to check that, but I'm pretty sure they have to take it out over the 10 years as well. I'm not sure. Do you know, Lisa?
I don't, I'd have to look that up.
I'd want to look that up. But there are people who are transforming their regular IRAs into Roth IRAs. And you can do that, but have extensive talks with your planners, because when you do that, let's say you take $1 million out of your regular IRA and put it into a Roth or 100, whatever number, you have to pay income tax on that money for the year. So the year you take it out. Now, that might be a useful strategy if you're younger. For me, that's not so attractive because at my age, I don't have a long stretch of time of life expectancy to make that financially an attractive thing to do. So that's something to look at with your advisors. Okay. Another asset that passes by beneficiary designation is the TDA, or tax deferred annuity. And I know someone asked a question about that. And I'll say that tax deferred annuities are contracts between you and the company you bought it from. And tax deferred, as the name implies, means that you've never paid income tax on that money. So when you take it out, you're going to have to pay income tax on it, just like the IRA. The details of exactly how it comes out and the timing of that and who it's going to, that is something that depends on the specific contract that you have. I like to say, if you know one TDA, you know about one TDA. So I can't give overall advice about that, but yes, it's taxable at the end of the day. And charity is a great beneficiary for a TDA because of that feature. And there were very aggressive sales of these over the years. I know a number of teachers who said that the salesman for TDAs came into the lunchroom and people bought these even within their IRAs, even though the IRA was already a tax deferred vehicle. So there are a lot of those out there. Okay, another way that assets pass is by operation of law. That means if you have joint property with right of survivorship, it goes to the survivor when you die, automatically, no questions asked. This can be a very useful thing, but it also has drawbacks. For example, let's say there are two people, husband and wife, and they own something jointly. Let's say they own all of their bank accounts and investment accounts jointly. One dies, the survivor has the whole thing. Great, easy, simple. But now what happens when the survivor dies? Let's say it's a second marriage. The survivor dies and gives it to his children, or he gives it to his new wife. This is not necessarily what wife who died first would have wanted. So let's consider another thing that couple could do. With some, first of all, they should consult with a lawyer and go through the whole scenario, and probably they're going to do some trusts. But one of the trusts that they might want to do is a charitable remainder trust. Let's say they're getting older and they want to downsize. But the house they're living in is one, let's say the wife bought it many years ago and paid $62,000 for it. That's what I paid for my first house many, many years ago. And let's say that now it's worth $2 million, $3 million. If to downsize, they sell that house, they're going to pay very big capital gains on the proceeds of that sale. What's an alternative? They could set up a charitable remainder trust, transfer the house to the charitable remainder trust, have the trust be set up so that it pays income to both spouses for lifetime. And then when the second one dies, whatever is left goes to the garden. They would be creating an income stream for life, a very handsome one, and a charitable deduction for their income taxes now. So again, this is not for everyone, but sometimes that can be something that solves a situation. I have a client now who, it's not a charitable trust, but it's a similar arrangement. And the income she gets each year is basically paying for her rent in a very lovely assisted living residence. So that's a possibility. So operation of law. Another thing is joint property. Make sure you check on deeds. It's not uncommon for people to get divorced. And under the divorce arrangement, the house was supposed to go to husband or to wife. But maybe they never changed the deed. At the very least, you're going to have an argument if husband dies and wife now has title to the whole thing, and that wasn't the intention. So you need to check on that as well.
Barbara?
Yes.
Barbara, we are running out of time. Believe it
Okay.
or not.
Oh,
I know. So I
okay.
wondered if I might be able to ask you some questions that have come in either
Sure.
prior to our webinar that weren't addressed or have come in during the webinar as well.
Okay, great.
So we talked about, someone had asked, and I mean, I could think of a very obvious answer to this, but I'm going to defer to you. Someone had asked, what are the benefits of naming charity in your will? And I'm going to say, besides the warm and fuzzy to know that you're actually supporting an institution that you love and that you've supported throughout your lifetime, are there any other benefits?
Well, you're going to go straight to heaven if you do. No, it's a great thing to do. And also it's an important lesson for your family, for your children and your grandchildren, that it's not all about me, me, me. It's also about our obligation to our communities. And so you're making that statement right there. And I would also say that especially if you've looked at the projections about your gross taxable estate and it looks like there'll be tax, make the gift now. Make some of those charitable gifts now. If you're going to put a bench in the garden, put it in now. And you and your husband can go and sit there.
Absolutely. And especially when we're dealing with the institutions that are, you know, like the garden, that's 120. Oh my gosh, we're 128 years old.
Wow.
It's great to be able to contribute to a charity to make sure that the next generation will have these wonderful memories that you did, whether it be during childhood or during adulthood with your family or even by yourself. The next, let's see, I have papers galore here and questions here and questions here. So I'm going to pick maybe two more. We had a lot of questions that came up about co-ops.
Aha.
Yes. And, you know, so someone had asked about, you know, that it was someone who's single and the co-op is solely in her name. And in her will, she's leaving it to her sister. And will there be a problem? And I think the obvious answer, and we had discussed this earlier, was that it really depends on the co-op board. And it really has to be a discussion, and it depends on what their bylaws are. But are there any other things that legal that I'm missing?
Well, yes, I'd say that if there's a co-op involved, there are going to be problems involved, because co-op boards usually have too many retired lawyers participating on them who find all sorts of issues. But the basic idea is that ownership of the co-op is one thing. Who gets the right to live there under the proprietary lease is another thing. And co-ops usually want to have control over both aspects of that. There are a couple things that this lady can do. One is she could put the co-op in her revocable living trust, but she has to have the cooperation of the co-op board, and it's a bit of a pain in the neck, but you can do it. And then when she dies, the co-op will go according to her trust. And depending on the co-op, there may be a separate requirement about sister meeting the requirements for living there. If you have named a charity, and I was involved in one of these, the co-op was horrified that the will said my co-op goes to my alma mater. And we had a lot of time, it was a lot of work for me, but we eventually got it settled. The answer, the better answer is that you would have the co-op in your revocable living trust, and it would say, upon my death, I would like my trustee to sell this and give the money to the charity. The net proceeds would be simpler. Next question, Lisa.
Next question. Oh, are there different taxes that need, whether it be estate, inheritance, or income taxes, that need to be considered when comparing a will versus a revocable trust?
No.
That was easy.
A revocable trust is exactly like you. It's your alter ego. It's you with a purple hat on your head.
Okay.
And its only tax implication is that you can put smart tax planning inside it to happen when you're gone for the future generations. But it's because you own and control it and you can change it whenever you jolly well please, it's the same as you. So
Okay.
no thanks. There are irrevocable trusts that do have tax implications, like an irrevocable trust to own your life insurance.
Mhm. Can I name the trust as a beneficiary of my IRA? 3 parts. Does the trust then liquidate the IRA? And who pays the taxes, the income taxes responsible for the IRA?
Yes, you could name your revocable trust as your beneficiary of your IRA, but it would be a foolish thing to do. And that's because a trust is not a natural person. It's not a human like we are. And so there would be different income tax implications for that. It can go to a trust that lives inside your IRA, but there are a bunch of complex rules about that. You're much better off having your IRA go to a named individual or to a charity.
The next question is, oh boy, let's see, any other new ones? How do I put my household furnishings in my existing revocable trust?
You can, and you should. What you do is do a deed of gift, which says, I transfer to my trustee all of the tangible personal property that is in my apartment or my house. And that gets it all in there. So that's a good thing to do. And there's another great thing to do is while you're thinking about your tangible personal property, number one, think about getting rid of some of it. And there's a great article in the latest New Yorker called The Practice about giving stuff away. Another thing is you can take your iPhone and with some, in my case, technical help from my son-in-law and granddaughter, I went around my apartment and I said, I made little short videos saying, oh, this is the dining room table that belonged to grandmother Dorothy and grandfather Earl, and they got it in 1918 when they took it out of the neighbor's garbage. You know, all those things. So it says, what is the significance of this thing? And you can get all of that on tape.
I do have one more question. Let's see. My nephew was not good at managing his money. Is there some way of putting money into an account that would pay him a certain amount each year after I pass?
Yes, and that is a trust. You can put that into a trust. Again, inside your revocable living trust, you could have a little thing here that becomes trust for nephew. And you can say, I want my trustee to pay income or income in principal or whatever the trustee thinks is sensible. And that is a good thing. In jail, getting a divorce, a business failure, all of those things can be protected against by having assets in a trust for them. And it goes for children and grandchildren as well as nephews.
My last question is, can you talk about irrevocable trust versus a revocable trust?
Yes. A revocable trust, as we said, it has no income tax consequences in and of itself. And that's great. And you can change it whenever you feel like it. An irrevocable trust, you cannot change it. Usually it will say things like, oh, the trustee can change some technical details to make sure this trust still works. That's fine. But the purpose of irrevocable trusts is sometimes to save taxes. So for example, if I have created a trust to own my life insurance and I've done it properly, this trust will be way out of the picture. It will be out of tax land. So my kids will get these insurance proceeds someday free of income tax and free of estate tax, which will be dandy. Another kind of irrevocable trust is the charitable remainder trust, which we discussed a little bit. Another thing is called an IDGIT, which stands for intentionally defective grantor trust. This is for estate tax planning. I put money in here. It's going to go to my kids someday. It will be out of my taxable estate. It will be a completed gift. Similarly, a qualified personal residence trust or QPERT. I could put my vacation house in this trust or my own house. And through various manipulations, all of which are legal, that will eventually go to my kids free of estate tax. But now let's think about, people might be wondering about irrevocable trusts to pay for their long-term health care. This is still possible in New York. It's called a Medicaid trust. And the idea is you create a trust, you put virtually all of your assets into it, and give up control of all of that. And you are essentially making yourself poor so that you can get Medicaid coverage. Medicaid, you can tell by the last three letters, AID, it is designed to be a safety net for poor people. There are requirements and thresholds of income and assets that must be met before you get it. So you can do this I don't do it. I have a colleague. I can make a recommendation for people to do this for you, but it involves putting your assets in a trust and giving it away, period, end of story. It's not yours anymore. You can arrange that your kids will be paying you, or you hope your kids will be paying things to you in the future, but you know, maybe they do, maybe they don't. So there are other ways you can think about for paying for your long-term care. One is that charitable remainder trust that we talked about before, where you put a big asset. I was using a house, but you could be, it could be investments that you have, appreciated stocks and bonds. You put it in there and it pays you income at a guaranteed rate for the rest of your life. That could be a way to pay for it. Long-term care insurance is expensive. If you bought it years ago, great. And I will warn you that if you have a policy now, please check it very, very carefully and talk to the person who sold it to you. Make sure you understand what it covers, what it doesn't, how you get it into effect, and how you can activate it when the time comes. Well, you need to understand it. And when you are sick or your spouse is sick is not the time to be trying to deal with the insurance company.
Well, Barbara, I think we have reached our limit here. I'm so thrilled. It's so good to see you after all these years and work with you again after all these years. It was such fun. I know I took a lot of notes, and I'm sure everyone else did. Thank you, Julie, for joining us as well. I do appreciate it. This will,
Barbara. I took lots of notes too, just to let you know. It was wonderful. Thank you.
Thank you again for taking the time to watch the video, Planning Your Estate from the Ground Up, which was live on March 4th. I hope you were able to take some information that might be helpful to your personal situation. If you have any questions about any of the content or about your specific interest or situation, please do call the Office of Plan Giving at 718-817-8545, or you can always email us at plannedgiving@nybg.org. Thank you again. Enjoy your day.